Age or date of birth are also things on an application that I don't think are really necessary, because you don't want somebody to say, well, they didn't hire me because I said I was 58 years old. DOC takes a very, very dim view of employers that ask this. Even though it's not per se unlawful, I recommend against doing it. Citizenship is, again, not something you necessarily want to ask, but you can ask whether or not somebody can lawfully work in the United States. Language fluency, I touched upon that before. Make sure if you're asking about fluency in a particular language, there's a reason you do that they need to for, let's say, customer or safety reasons. Place of birth, again, this could be some sort of discrimination based upon national origin. That's normally an irrelevant question and not one I would recommend. Gender, normally not a question you need to ask either. That's somewhat self-evident by their name, so I'd recommend not asking that question. Asking about children or dependents, it's not something I would have on an application because, again, there could be some sort of association discrimination. Marital status, also not something that you want to necessarily have on an application. You normally can ask that question later on if, for instance, you're offering benefits to families. Name or occupation of spouse. This is typically an irrelevant question and not one I would ask, and it just leads to problems under some of the marital status or other association discrimination type claims. Believe it or not, asking whether or not somebody's a homeowner or renter, in some regions, statistics show that a greater percentage of minorities and females do not own homes as compared to white males. So I wouldn't ask this question because, again, it could show that there's some sort of adverse impact. Same thing can be true of surety bonds, rejection, or forfeiture. That can get into some bankruptcy protections as well as having a disparate impact on certain racial minorities. Availability for weekend, overtime, or other work. This can get into some of the marital status issues. What I would more recommend is you tell somebody what the job requirements are. This is something normally you'd want to deal with in an interview, and then find out whether or not they can actually do the job. I have a lot of employers, believe it or not, who ask somebody's workers' comp history. While, again, that is not a per se unlawful question, it's a really bad question to ask because what are you going to do with the information? If you decline to hire somebody because of a workers' comp history or some sort of health characteristic, they can come back and say they were not considered for the position because of that, so be careful. There are armed forces record protections. You can ask, about their job history, including armed forces, but you can't decline to hire someone simply because of their service in the military. I talked quite a bit about criminal records. I do recommend, at least in Florida, that you ask more than just, have you ever been convicted of a felony? You are lawfully allowed to do that, and you're going to want to know more. For instance, have you ever pled not guilty or pled guilty or no contest to a case? Or even, you may even want to know whether or not they were arrested. I think these are important things to know for an employer, and then you make the determination whether or not you're going to exclude them based upon the information you learn. If you have a section on the application where employer comments can be made, be very careful that whoever's making the hiring decision, states, for instance, for office use only, it invites stray comments or impressions to the employment application. I would have those comments done separately on a separate piece of paper, because if somebody makes an offhand comment like, she wasn't very attractive, or, this person was too old, that could be a real problem. So I would recommend that you do any comments on an applicant separately. A lot of people ask how long you should retain the applications. Normally, if somebody has not been selected, the recommendation is to keep it for at least 1 year. You can store it electronically if you prefer. I prefer the hard copy if possible, but there are other laws out there, other states that require you keep it longer, but normally 1 year is a good time to keep it. A couple other things about applications. I can't tell you how many clients I run into who don't either ask about unanswered questions on an application or don't thoroughly read them. Normally when somebody doesn't answer a question on an application, they either have a very hard time following instructions, or in the alternative, they don't want you to know the answer. So make sure during the interview that you're asking them about an unanswered question, or ask them to refill it out and thoroughly answer the questions. And make sure you read the whole application. I went to University of Florida. If I just picked up an application and said, "Oh, a fellow Gator, let me hire him," I may be missing some important stuff. So there's no reason not to read the entire application. You would be amazed what you learn about somebody. Other things to consider about hiring are offer letters. I see a lot of people mess offer letters up. If you're going to have an offer letter, you want to make sure that it sets out that for the most part the terms may change. Also that this person's not guaranteed employment for a specific period of time. So if you're using offer letters, you want to make sure you're not forming an employment contract with them that you had not intended on doing. Employment contracts are also something to look at. Again, when somebody wants to come to work for you, they'll normally sign anything. So if you want them to sign a non-compete or a jury trial waiver or a class action waiver or some sort of non-solicitation of clients, the very beginning, the hiring process is the best time to do it. And so people understand what they're getting into, and you get them to sign it at the very beginning. Also, a lot of people say the first 90 days is a probationary period. I think that's important to do, but for a different reason than most people think. I run into employers that think that you can get rid of somebody for any reason you want in the first 90 days, even if it typically would be a bad reason. I think that's a true misconception. I don't know about you all, but I expect my employees to do a good job on day 1 and day 91. So while it's important to have a probationary period because that could exclude them from unemployment compensation if they're termed within the first 90 days, it's not for the reason that people think that, well, that just means it's so much easier to get rid of them in the first 90 days. At least the UFC doesn't take that view, and most courts don't either. Some other issues that come up for pre-employment testing are ADA concerns. The only unlawful, really truly unlawful question during an interview is asking somebody if they have a disability. You can ask them if they have an essential function, they can or cannot do the essential functions of the job with or without a reasonable accommodation. So be careful about some ADA concerns. Things such as medical examinations, drug testing, alcohol tests, performance of job-related functions, agility and fitness tests, and genetic testing, written exams. These are things that normally should be done post-conditional offer of employment. The EEOC takes a very dim view of folks who try to have medical examinations pre-offer. Matter of fact, they find it to be unlawful. So you need to be very careful about doing these things. There are also a lot of willy-nilly companies out there that are giving these job tests or psychological testing. I take a pretty personal dim view on this stuff unless you can truly show they need to do the job. Now, for instance, if you want to go work for the police, it's pretty important that you have to, be agile and can run and chase a suspect. But those are the type of exceptions you need to look at. If they have a mundane job, if you want to see how they do it, that's fine. But you need to make sure that it's truly related to the job. Polygraph exams are very hard, and there are very few employers that are allowed to do this. There's the Polygraph Protection Act of 1988, and most type of employers are prohibited from directly or indirectly requiring or even suggesting that a job applicant submit to a polygraph test. Federal, state, and local governments are exempt, and there are certain jobs, high-level security jobs that may require it, but be very careful. Same thing goes with honesty testing and psychological testing. Make sure you know what you're doing and why you're doing it. During interviews, before you do an interview, I always recommend that you write down what questions you want to ask. Only ask questions that are really necessary to the job. I've gone through some just crazy interviews where people have asked me questions that probably are unlawful in context or completely unrelated. Questions like what type of animal you would be if you were an animal. I'm sure somebody thinks that's reasonable or that's an important answer for me to give to them, but it's not a question you want to ask. So make sure that you write down the questions beforehand so you don't go, quote-unquote, off script.